Okay, I hope so. Now you guys are can listen to me. Uh, if somebody can confirm, if you guys can listen to me, so we carry on with our session. Now it's fine. Okay, that's good. So now we will briefly first discuss the recent immigration updates, and in the end we will answer your simple questions. So first is students on the F-1 visas doing OPT must enter employer information in the system. We have, and earlier also during the previous session I have mentioned that they are trying to add that in, that the students who are trying to put in the OPT information, they must enter the employer information in the system, and that the system is the service and the USCIS system. Then California will challenge current DACA restriction. California state is preparing to challenge the current DACA information, but they are putting restrictions on that and the guidelines. USCIS implements DHS guidance on DACA. So this news has just come this morning, that and it is available with all the points. It is available on our Facebook page as well as on the uscis.gov, where they have provided the guidelines which the DACA students, and we will discuss them also here, needs to enter in their application and needs to provide the information which they need to follow. So USCIS guidelines, I will briefly try to put them in there because you know it's very detailed. If you want to read them in detail, they are in detail on our website, and they are in detail on the uscis.gov website, but over here we'll briefly give you some points that what are the new regulations and guidelines with the Department of Homeland Security wants the students to follow for DACA application. Number one point is under USCIS implementing guidance. We will reject all initial DACA requests for aliens who have never previously received DACA and return all fees. They are saying that DACA will be issued to the people who have already granted the DACA. So it's kind of an extension, and they are not taking in any new applications, and they will return the fees. If any application will be sent, it does not qualify under that criteria, they are going to return the fees as well. Number two, for approvable DACA renewal request, USCIS will limit grants of deferred action and employment authorization under DACA to no more than 1 year, but will not rescind any currently valid 2 years grant of DACA or associated employment authorization document. So they will limit the grant of deferred action for no more than 1 year, which was usually 2 years. So that is the change which has come in the DACA application. Number three, USCIS will generally reject request received more than 150 days before the current grant of DACA expires. So what happens is, whenever you put in some application or some kind of petition, there is a certain time period you can add in that petition or application, or file for extension, or file for a certain time period you file for before the expiration. You can file for the extension of that particular application and particular petition. So the rules are different for all kinds of application. For this, they are saying that it should not be put in the system before 150 days. So it should be within 150 days and 120 days before their current grant of DACA expires. The validity period should fall between 4 months to 5 months for them to apply for the DACA renewal. USCIS will only grant advanced parole for travels outside the United States to DACA recipients pursuant to the new guidance, which provides for a determination that parole of the alien is for urgent humanitarian reasons. So as we know that the DACA status is a deferred action. It doesn't give you any kind of status like permanent residency or any other status that we have, or any other kind of petition that comes with the approval. So in the deferred action, if their entry is not legal, as they are not establishing for DACA, if they want to travel, the travel permission can be given by the DHS, but it should be based on the humanitarian grounds also. There should be reason based on humanitarian grounds that why the applicant can qualify for the travel documents to travel outside of the United States, and then can enter United States without any detention or any being restrained at the border. Okay, so this is it. Now we will discuss about my favorite subject, which is the F-1 international student visas and then transfer to H-1B. So what happens is that when the students from all around the world, they come to the United States on the student visa, which we commonly call F-1, and there is also one status of the student as M visa. When they come over here and they complete their course of studies, then they are allowed to file for the change of status based on if they have a petitioner available who can sponsor them. It's an employer, it's a US company which can apply the petition, which we call the H-1B petition for the students. Now once the students complete, the international students complete the course of their studies, they are given the OPT time, which is usually 1 year. And if they qualify under the STEM, there is an extension to the OPT also. But usually the 1 year time period is given to them, so they can find a job in their profession. And if they have any individual company available or any corporation available who is willing to file the H-1B petition for them, because the H-1B petition is filed by the petitioner. So this company, if they secure a company like this, or who is interested in hiring them, even if they're working with some other company on the OPT, and they're working with the ABC company, and the XYZ company wants to petition them for the H-1B, yes, they can do that. So if they have a petitioner who is ready to file the petition, the process for the first H-1B always comes under quota. So first they qualify under if they secure their name in the quota, then they can file for the H-1B extension as the second extension. And after the filing of the employment based petition, that is I-140, they can even file for the 3 years and 1 year's extension based on if it's an approval or it's a pending filed I-140 petition. So at this stage, first they need to get their name picked up under quota. So all the companies, they file, usually what the practice was that April 1st was the date when all the companies needs to put in their petitions for the H-1B with the USCIS, and then they generate a quota, electronic quota system, and then under which 85,000 applications were supposed to be picked up, out of which 65,000 comes under bachelor quota and 20,000 come under master's quota, that is US master's quota. This system has little bit changed, and this year, and the Department of Homeland Security have started a registration system where they say that you can first in the third week of March, you need to put in your names and your information in the online DHS system, and based on that, whoever name will be picked up, their attorneys will be informed, or the petitioner will be informed to put in their H-1B petitions with the USCIS in certain time period, and then give the deadline also. This year what has differently happened also is that the initial quota was picked up in March, and the cases which were picked up and the beneficiary petitioners, they were told to submit the applications in a certain time period. So the applications were submitted, those H-1B were submitted. Again, this has happened, what we are receiving also, and there must be other law firms also, that we are receiving the email notifications from the Department of Homeland Security, where they are further picking the cases which were not initially picked up in March or in April. So they are picking up, and we are receiving their case numbers, and we are receiving the instructions where they are saying that, okay, move forward and provide us with the H-1B submission and do all the process of the labor condition application and putting the paperwork together and provide us with the whole H-1B petition by this certain time period, so they can process it. Now this can be any reason why they are doing that. This is very odd. Usually what happens is that when the quota number is not filled up, they do keep it open, or but it's not that it comes as a second lottery. They do keep it open, and they say, oh, you know what, we will let you know. Apparently initially they have said that the quota has been filled up, and 85,000 petitions have been picked up, and we are informing the petitioners and we are informing the attorneys with the names and with the numbers for the cases which have been picked up. But now it seems like that this system has been changed or been changing, because there are so many changes happening right now with the DHS in their system. So we keep our fingers crossed, and we hope so that it turns out to be very well for all the petitioners and for all the beneficiaries who have applied for the H-1B and who needs their name to be picked up in there. So once the H-1B, so we move forward to that. Once the H-1B gets picked up, they start working with the petitioner. It's picked up, it's approved. On October 1st, they start working for the petitioner on this new job. And based on that, even the petitioning company or any other company who's willing to sponsor the beneficiary, they can start the green card process, which we call employment-based green card process for their employees as well, and can move forward with that. We have if you have any questions, you can ask us. It should be single line questions. Detailed questions we are unable to answer here. Also case law questions we cannot answer here because confidentiality is involved. But if you have simple questions which you can ask us, and we will like to answer those questions to the best of our ability, and for in the simple explanation, so you can understand the answer in the best manner. We have certain questions which I have received, and I have mentioned earlier also. These are the questions we receive online. I'm very happy when people come and interact with us online. Put the questions there. We like to answer those. But if they are not available at this time when we are doing live streaming, or they cannot ask us questions over here, they can send us questions via messenger, via email. We have our email address here, or they can send us questions through other mediums, and we will try to, as we grasp them for the next our live session, we will like to put them down and answer them. But the only thing which kind of concerns me is that when we try to get these questions from various mediums, sometimes we miss on certain questions. So I'm sorry if we miss on certain questions. You can ask those questions again, or you can come online and share our presentation with you guys, and you can ask us questions. Also, like I mentioned before, the case law questions, the case related questions which involve the facts, cannot be discussed over here because of the confidentiality involved. So if you have any questions, you can ask us. You can take the consultation, you can ask the questions, and also there are certain documentations involved which needs to be reviewed before answering these kind of questions. So definitely we don't have time during this half an hour to answer that. So we will love to answer those questions, and that is besides. But we have certain questions which I like to answer. If you have any questions to the listeners, I can see there are people who are listening. If they have any questions with regards to F-1, or with regards to the change of status from F-1 international status to H-1B, they can ask us those questions as well. Short questions should be that. Okay. Now we have certain questions which we have written down. I will like to say these, mention these questions, and will like to answer those. Number one is the Number one is the question. I have applied for my father for green card process. He left USA during this process. Family-based petition is filed yet. Okay. What can I do now? This is Mr. Liaquat from Kentucky. Okay, Mr. Liaquat, your questions are like statements are little vague, but what I understood is that currently you have just filed the family-based petition for your father. Maybe while, in my understanding, that when you file the family-based petition for your father, he was present in the United States. And when you mention that family-based petition is filed, yet means that you have only filed the I-130 petition, and yet the adjustment has not been filed during his stay here. So you have the other option available. If during that time you file the family-based petition, that is fine. There's nothing wrong with that. You can find even the parents are here, or even the parents are back there. Your father is back there in the home country, went back there. But the second process involved, which is either can be consulate process or can be adjustment of status, that is the second step moving forward. So if he is not present in the United States currently, once the I-130 gets approved, then you will move forward with the consulate process, and he will come back to the United States to secure his residency status by going through the interview with the consulate. That is, after going through the NVC process, that is the second stage. All the documentation was submitted, and then your file is transferred to the related embassy or the consulate, where the interview for the family-based petition is conducted. And once that interview is done and the visa is issued, your father can come back to the United States, and he will secure his permanent resident card over here in the United States. If during that time, while the family-based petition is still pending, and your father he's on a visitor status, he comes back, and after 2 months, with his 60 days lapsing period, he is eligible to file for the adjustment of status within the United States. So that kind of eliminates the consulate process, and the consulate process is changed to the adjustment of status. Okay, and next question is, initially enter USA without inspection. I have been living here for more than 10 years. I have no criminal charge on me. I am married to a US citizen. Can I apply for the green card process now? This is Lydia from New York City. So again, we'll read the question. Initially entered USA without inspection. So it's an EWI. We call it an EWI, entry without inspection. I have been living here for more than 10 years. So she has been living in the United States for more than 10 years. I have no criminal charge on me. So there is no criminal history. And then I'm married to a US citizen. So she's married to a US citizen. Can I apply for the green card process? See, if in general process, if you are married to a U.S. citizen, your U.S. spouse can petition the family-based petition for you, and if you are present in the United States, you can apply for the adjustment of status, which we call green card process within United States. But what happens is that if the entry is not legal, the entry is not legal means that there is no stamp available. When you enter, if you come through the airways, or you cross the border, or you are coming from Canada, or you are coming from Mexico, and you cross the border without any visa, that is without any visa, so that entry is not legal. If the entry is not legal and you are living here all this time, so you are not eligible to file for the adjustment of status. If your entry is legal, and if you did not maintain your status, you enter on a B2 status, any other status, you did not maintain the status, you get married to a US citizen, still you are eligible to file for the adjustment of status as per the rules and regulations of the immigration law. But if your entry, you cannot prove a stamp, it's not stamped, your entry is not legal. So at the time, if you get married to a US citizen, though you are eligible for green card, but it will not be through the adjustment of status. In this situation, you have to file a waiver, which is I-601A waiver, and you have to get your green card through consulate process. That is, first you go through the I-601A waiver, and then upon approval of the 601A waiver, you go through the NVC process. Your appointment is set up at the embassy or consulate in your home country. You go back, you get the stamping done, you re-enter with your visa, and that will be your legal visa status within United States, and you will be given the permanent resident status. So it's a deviation from the simple process because of the EWI, that entry without inspection. You can contact us if our law firm, we do all the times lots of waivers, all kind of waivers, which include 601A waiver, 601, 212 waivers, J1 waivers. You can contact us, and if you need any more information with the facts or with this documentation involved. There is another question which says, I'm married to a US citizen. and applied for the resident status through him. So married to a US citizen and through him applied for the adjustment of status, I believe. I have a conditional green card for 2 years. So she already got the conditional green card, which is given for the 2 years for the marriages which are less than 2 years of time. So if you get married, like this lady, Miss Gina from Texas, she got married, and it's less than 2 years of time period, and the husband applies for the green card because he's a US citizen. So you get a conditional green card for 2 years, and you need to remove the conditions before the expiration of the conditional green card. So before the 2 years time period, you put in your removal of the condition application to remove the condition and get the 10 years green card. But even before that, based on the marriage, you are eligible to file for the citizenship after 2 years and 9 months of getting the conditional green card. So still you are eligible. Even in some situations, we file for the citizenship of the applicant if they become eligible, even when their removal of the condition application is delayed and still pending. They become eligible when we do move forward with the filing of the citizenship for them. I think so we answered this question. What is the next step for me? So the question, I have a conditional green card for 2 years. What is the next step? Which I have already explained, that you have to file for the removal of the condition before the expiration of the 2 years time period. And once they process it and they approve it, they give you a 10 years green card. But you, based on your married to a US citizen, you become eligible for the citizenship after 2 years and 9 months of getting the conditional green card. Then we have a question. The next one is that I've applied for my sibling in the year 2009. The petitions are still pending. How much more time will it take to process? So this is Chanda from California. So she's saying that Miss Chanda from California is questioning that I have applied for my siblings in 2009. See, when you apply for your siblings as a US citizen, it takes a longer time period because the timeline of the processing timeline depends on the priority date of that particular category. And unfortunately, for the sibling category, it's a long time period. So we follow, when we are following that, if the petition is already filed and we are moving forward and seeing that what time cases they are processing right now, we follow the visa bulletin. So visa bulletin comes out by the Department of State every month, by the 10th of every month for the next month. So we have already visa bulletin out for September 2020, and they have different categories where they give the timeline, processing time as per their priority date. The priority date is established by your receipt notice. When you file a case, and on the receipt notice they said that this is the priority date, this is when we receive your case, and that establishes your priority date for that particular case type. So over here, Chanda has applied for her siblings in the year 2009. So as per my information and as per the most recent visa bulletin, which changes every month, the dates changes every month, processing time changes every month. So as per for most recent information, the visa bulletin shows that they are processing the siblings visa which were filed in 2007. So 6 to 7. So seemingly there is like 2 years time period in between before processing that. We have the last question over here from Mr. Liam from New Mexico. The question is, I am on L-1 visa in the USA and wants to get a maid from my home country. Is it possible? Very interesting question. You know, this question so many ladies ask me that, oh, is there any way we can get maids from our home countries? We miss them. They actually run our homes, and you know, they cook food, and we have such a blessed life with them, and I understand all that. And luckily, yes, the answer is yes. In particular situation, based on like he's on Liam is on L1 visa, so yes, they can. If you are on L1 visa, you can apply and you can get your maids from your home country. Now there is a particular process to apply for the maid visa, and I think so we start receiving calls for the maid visas. But there is a particular process that we follow with the consulate. It is called the B1 visa, but with certain different requirements and certain restrictions, which get involved the Department of Labor over here in US also. So there is a bit different process, but yes, it's doable, and you won't believe how many people end up having their maids in US and having a very blessed life and enjoy their life with everything covered and yummy food cooked for them. So I think so our time is over. I don't see any questions over here which are asked on screen. I see Waji Naseem. I hope you are doing well. And I see Ali Raza. Then we have certain names here which I can see over lines, lots of people. I do prefer, please do ask us questions. If you have any question, like I'm saying, if it's a short line question, I can answer that question over here. If you have detailed questions or if you have facts involved in that, then the confidentiality gets involved, and it's not, our requirement is not to discuss the cases where the confidential personal facts are involved. So for that you have to set up a consultation and discuss your matters with us. On the screen you will see us, our details, the telephone number, Instagram. Do like us on our Facebook page. So if you like us on our Facebook page, you will start getting our information. We post minute to minute, second to second immigration information, which becomes available to update you people about what is happening in the immigration world, what are the changes, how are they related to your matters, to your case. So it's very important that if you want to do that, you can click like button over there, and you will start receiving our updates that we post on our Facebook and that we share on Twitter, as well as on our LinkedIn account and our Instagram. It was very nice talking to you. Thank you, Waji. Thank you very much. If you have any question, we will be waiting for that, and waiting to hearing back from USCIS. Yes, Waji, there is delay. Okay, now let me say some words about that also. That the cases which are filed and which are in delay, that means that they're processing in their processing time, but because of the pandemic, their processing time has been prolonged. The immigration is open, officers are sitting there, officers are working on these cases, but the number of the officers has reduced, so the caseload has gone up. So when the caseload goes up, their progress or their results come slowly, or the more time they take on per case to work on. So we are getting results, we are getting correspondences from the USCIS, and hopefully we get all the good results for all our clients and for the people who are interested in changing their status or in filing for the adjustment or the extension of their stay. So we will see you next Monday. We will update you what information we will be sharing next Monday live, what kind of issues we will be discussing, and we will like to see you again attending our live session. And if you have with your questions, if you have any questions, we would like to answer those. Thank you very much. You have a blessed evening. Thank you.